Welcome back to our weekend review discussion. Now, although the Independent Electoral and Boundaries Commission is opposed to changes to the electoral laws just days to the election, they are, however, in agreement with some of the changes proposed in the amendment bill. A case in point is a clause incriminating returning officers who refuse to sign forms 34A and 34B. Will it help cure the election result credibility dent? Well, here's Commissioner Jacob Gulie on the same.
Or refusal to sign results. The proposed change in law is that there is a new insertion of 6A, notwithstanding any other provision in this Act or in any other written law, a presiding officer or a returning officer in an election who, in relation to the prescribed document containing the results of the election, A, knowingly fails or refuses to sign the document, B, knowingly fails to complete the document, or C, willfully submits an incomplete document, D, willfully alters or falsifies the document, commits an offense and shall be liable upon conviction to imprisonment for a term not exceeding 5 years. Our remarks as a commission is that this proposal places an obligation to the returning officers and presiding officers to sign and completely fill any election documents, including statutory forms, and lays criminal liability in failure thereof. So we do welcome this. This is over, however, we feel it's over legislation, considering that firstly, the mischief sought to be cured never occurred, if it doesn't occur, or it never occurred. And secondly, the fact which would constitute an offense under this section are provided for under Section 6 of the Election Offences Act. So there is need to harmonize with that particular section of the Election Offences Act. And generally, we do accept the proposal.
All right, so that is Commissioner Jacob Gulie there on the returning officers. The proposal by Jubilee is that returning officers who knowingly or willingly fail to sign forms 34A or 34B should be jailed for a period of about 5 years. Let's hear your thoughts on this, Dr. Muiru, because so far we're not sure whether this is a decision reflecting the entire commission, including the chairperson therein, but we're still discussing forms 34A and 34B. Initially, Chebukati was of the view that there are election officers and returning officers have already been trained under the existing election framework, and it will be hard to retrain them if these laws are passed afresh. Your thoughts on this?
First and foremost, Commissioner Gulie did say that he is representing the position of the commission. Mm-hmm. So I would imagine that that to be true. So, it's a position of the commission. But having said that, let's remember that this is not a proposal that is coming out of the blue, because the Supreme Court did find that, or at least the case as it was presented, there are some forms that had not been signed. What I'm not clear about, because of course I'm not a lawyer, is the majority judgment, scrutinized some forms, and then the minority, the dissenting judges also scrutinized some forms, and then there were accusations about which particular judges had not looked at which particular forms. Mm-hmm. But I'm not sure. But in the interest of clarity, I think this looks like a fair amendment, so that if an officer who is supposed to be signing a document for some reason fails to sign that particular document, they should be held liable for that particular, so that we don't end up where we are. Right. So this is curative more than it is anything else.
Right, but will it really cure, before I come to you, Professor Tumbo, will it really cure the credibility dent within the IEBC? Because even when the proposal first came up, the opposition took issue with it, saying some of our returning officers did not sign these forms, not on their own will, but because of external pressure, because they were kicked out of these areas where the forms were being signed. Will this really, cure that credibility dent? And how will we be able to ascertain whether there was indeed external influence on these returning officers not to sign the said forms?
The good thing about a criminal case is that it will end up in court. Mm-hmm. And the court will logically look at all the evidence, including what the returning officers themselves might say in their own defense, whether or not they were compelled to not to sign those forms, or they were kicked out. So that would, provide, good evidence for court to evaluate, so that we know that, and of course remember that there are witnesses, there are observers in the polling stations, there are media people in the polling stations, there are, agents, all those kinds of people will come to court and say that indeed a particular returning officer was expelled, or, was compelled not to sign, or something to that effect. But at the moment, as we stand, there is no clarity on that particular issue, and I think it's an area of weakness, and this particular law is supposed to take care of that.
All right,
yeah.
All right, Professor Tumbo.
My understanding of this particular one is that in terms of the sections submitted by Commissioner Gulie, some of them clearly have a curative effect. There are aspects of it that are not curative. One, for example, is that particular returning officer allowed to say, signed, after he has signed, he says, with the reservations. Because even when we have a board meeting and the majority, all right, approves a resolution, you normally say, I support, all right, with the reservations. Right. Now, in my view, this particular aspect will provide for cases where one complies with the law, all right, but has issues that they will be willing to explain in a court of law. Two.
But just before that, won't those results still be read out as the final results?
You see, the point is this. As far as I'm concerned, this particular amendment is only effective partially. It is not comprehensively. Because, you see, for example, a polling station is a stage for drama. In a highly contested election like this, there will be people in the polling station who are technically neutral, but operationally partisan. For example, from my experience, even the security officers you have in the polling stations have political positions. And instead of verbalizing them, they do it through their actions. And there is evidence from the last election where security officers were, one security officer is obstructing an agent while another one is helping a voter, so that to make sure that voter votes in favor of his interest. If he was in NASA, he makes sure that voter votes for NASA. He was in Jubilee. So one of the areas that, in my opinion, these amendments need to cure is there is too much emphasis on security, but the people who have a security assignment are not restricted to security assignment. In fact, Michelle, I'll say this, even at the national level, if you have a person designated, let's take an example, a DPP. Now, although he has a designation as a DPP, in his day-to-day life, he is normally pulled aside to perform other functions, which he is not officially supposed to perform. So until we clean up what goes on in the polling station, this particular amendment is not comprehensively curable. Dr.
Mwiru.
I wanted to respond and say that while I agree with part of what the professor is saying, courts exist for a reason, and courts are very critical in a democratic ecology like ours. They are the ones that are supposed to help us resolve our political differences. So political differences will always be there because, as Prof has identified, at the polling station, there are all these characters who are there, and they are most of them are partisan. But the only, the only body that has the capacity to look at evidence impartially is the court. So let these matters go to court. And, there are a lot of people who, of course, who are supporting the courts when the courts say something that advances their particular, belief or viewpoint. like in the case of the Supreme Court, but then again, there are also, other arguments which look at, the court as an institution that shouldn't be supported. So in this particular case, since we are talking about a criminal act, the possibilities of a criminal act, let us take the returning officers, if they have committed any crimes, to courts of law. The courts will then adjudicate that matter using logic, using legal reasoning, which is an accepted convention, in all democratic situations. So this is a very critical issue because it goes to the issue of political culture. What kind of political culture do we want to cultivate in this country? Because we have the option of resolving our differences through intimidation, through violence, through all kinds of unconstitutional means. But if we are believers in the rule of law, let us take these matters to court. And what this law is trying to do is bring clarity to that particular area by sending offending, returning officers to court where they can be, impartially heard.
But it doesn't, and this is where I'm coming from. There is what you might call a refusal by conscience, where a person, as a matter of principle, has decided that I would rather go to jail than sign this thing. And he may decide that he's not going to sign it because she or she has a good reason. My view is that the current atmosphere where there is general disrespect and disregard for the courts, you cannot then leave a loophole which you expect to be cured by a court that is under the barrel of the gun. So my view is that let's deal with this thing at the beginning, rather than wait at the end.
Yeah, I want to
let me finish, Dr. My view is very simple. Are you criminalizing, all right, a decision based on a clear conscience that is related to the truth?
All right, Dr. Muiru.
The whole issue of what's called a consensus objection is a matter that has been adjudicated. Adjudicated by courts all over the world. There's a rich jurisprudence on this particular issue. Particularly with regard to people who oppose wars, for instance, on grounds of their conscience, and so it is not a new thing. So if a returning officer for some reason feels that they cannot sign a particular form because of their belief or conscience, the law provides for the court to adjudicate that. The returning officer will go to court and say, I could not sign this particular form. I am before you, because of the fact that I'm opposing this on the basis of my conscience. And the court will listen to that and determine if indeed that is, valid or not.
All right.
But the results would have gone in total disregard of that opinion. The results would have been read out in total disregard of that opinion, because the court is not going to decide on what the numbers were.
So
the court also adjudicates on matters of petition. So, it is within the ambit to look at that also.
All right. Let's also consider the fact that, I want to take a short break, the fact that some of these amendments proposed by Jubilee are meant for just that, to ensure that should there be no election, should there be, another election, possibly will not be another petition taken to the Supreme Court. But we'll come back to that. Let's take a short break here on Morning Express. At this point, we'd like to release our viewers watching us on KTN Home. Life and Style is coming up next. But our conversation on the Weekend Review continues. When we come back, we are still focusing on the Independent Electoral and Boundaries Commission. IEBC did have meetings with both parties earlier this week, but seemed to be unable to tone down the hardline stances being taken by both parties, with Jubilee saying their amendments to the election laws must be reviewed, and NASA saying IEBC does not seem to have the goodwill to meet their irreducible minimums, and will be continuing with the street demonstrations today. Do stay with us. The conversation continues in just a moment.